Good day, everyone. We are going to cover in this podcast the interplay between the Americans with Disabilities Act and the Family and Medical Leave Act. The first session of our podcast, I'm just going to generally go over the ground rules of both of these laws and talk a little bit about how they interplay. But as we go through the podcast, we will obviously get into some of the more nitty-gritty of how these two laws do interplay with one another and how they affect how you handle your leaves of absences with regard to your employees who do need leaves for medical conditions. First of all, when I talk about the Americans with Disabilities Act and the Family and Medical Leave Act, I do like to point out that these were laws that were passed in the height of campaigns, and therefore they do have some language in them that have been very troubling for the courts in trying to interpret what the Congress really meant. And what I mean by that is when laws do get passed in the middle of a campaign, what we typically see is that they get passed very fast, and as a result, there tends to be ambiguous language that does seem to become a little bit of a problem in the court system, and we've certainly seen that since the passage of these two laws, and as a result of the fact that the courts have had some difficulty in determining what Congress really meant when it passed these two laws, we have had since a complete overhaul of the regulations that the Department of Labor passed with regard to the Family and Medical Leave Act, and we've had a significant amendments to the ADA, which was specifically designed to overturn several court decisions that Congress disagreed with. But as we go through this interplay, we do want to talk about the ADA and the FMLA, and let's just talk a little bit about the ground rules here. Whenever we are talking about these two laws, I do feel that frequently a violation that occurs on an employer's behalf is in large part a result of a lack of communication. And when we talk about the ground rules here, it does require some participation on the employer's behalf and obviously also the employee's behalf. It also requires interaction between the employer and the employee, and sometimes the employee's medical professional. And of course, we also know that anytime you are dealing with medical information of your employees, there is also an attendant confidentiality requirement. So when we talk about these ground rules, we will be talking about what do we mean by participation, the interaction, and of course the confidentiality aspect of these two laws. When you look at the between these two laws, it's important to understand the objectives of these two laws. When we talk about the Family and Medical Leave Act, it is very job protection statute. Except in very limited situations, the FMLA requires an employer to provide unpaid leave for up to 12 weeks per year, and it requires the employer to return that employee at the end of the leave to the exact position they had or a substantially similar one. And the FMLA does not take into account how difficult this requirement may be on your organization. In other words, there is no undue hardship defense with regard to the employee's ability to take this leave. Now, you may be in some states where you may be required to provide more leave than is required under the FMLA, and of course in that situation you would look to your state law as far as the maximum leave that an employee might be entitled to take. The ADA, on the other hand, is what I call a partial job protection statute. It is designed to require an employer to provide reasonable accommodation if necessary so that the employee can perform the essential functions of their job. When we talk about the interplay between the ADA and the FMLA, however, we're usually focusing on the fact that a leave of absence can be considered a reasonable accommodation under the ADA. And of course, when we talk about leaves of absences, that automatically triggers the thought process that we have under the FMLA. What's different under the ADA, however, when we talk about the type of leave that you might be required to give an employee due to a medical condition or to allow them to be able to perform the essential functions of the job, the ADA does have written into it an undue hardship defense. In other words, you only have to provide this leave if it is reasonable and it does not impose an undue hardship upon your organization. Excuse me, the basic obligations of these two laws The ADA, as I said, prohibits discrimination against qualified individuals with a disability. The ADA does not require an employer to lower its job requirements, and it does not require employers to give individuals with a disability preference over individuals who do not have a disability. What it requires is that the employer would provide some type of reasonable accommodation, if necessary, to allow an individual with a disability to be able to perform the essential functions of their job. The FMLA, when we talk about the interplay, we're usually, again, focusing on the leave of absence aspect of the FMLA that may be required to provide leave for an employee with a serious health condition, although the FMLA does provide for leave for other conditions, but usually does not trigger ADA obligations. And those other conditions that you would have to provide FMLA leave would be due to the serious health condition of a family member, as well as the employee, a military exigency, and the birth or adoption of a child. And also, with regard to military caregiver, the FMLA has been amended to require an employer to give up to 26 weeks in order to care for a member of the military who has suffered an injury or illness in the line of duty. That 26 weeks is a one-time 26 weeks to deal with that illness or injury of that family member who has been injured or had an illness as a result of the line of duty. So it's a little bit longer than the 12 weeks that we see typically when we talk about a serious health condition of an employee's family member. But as I said, when we talk about the interplay between these two laws, we're usually focusing on the serious health condition of the employee and, of course, the leave of absences that might be necessary to deal with individuals who have a disability who can become qualified for the job, with or without reasonable accommodation. There has been some, I think, misconception among a number of people, and it's probably because of the media and the media not fully appreciating what Congress did with regard to the definition of disability. The definition of disability has not changed since the original passage of the ADA. It is a mental or physical impairment that substantially limits a major life activity. What Congress did in the amendments, what I think that sometimes the media suggests that Congress changed the definition of disability, but it did not. What Congress did in the amendments is said that when we interpret this definition, and that is the mental or physical impairment that substantially limits a major life activity, and when we interpret that, it has to be broadly interpreted. That particular provision of the amendments was designed to overturn a U.S. Supreme Court case in which the court said that we looked at the definition in a very strict manner, and Congress did not like that decision, and that's why they passed the Amendments Act to now require courts to look at that definition in a very broad way. The statute, as I said, protects qualified individuals. They still must be able to perform your job requirements. And when we talk about job requirements, we do look at essential job functions. And when we look at essential job functions, the courts will give deference to your job description. So it is important that you do have written job descriptions where you have outlined what job functions you do consider to be essential, and courts are required to give deference to that definition of what you think is essential, as long as you have that in place before you start recruiting any type of candidates. And of course, we do look at with or without a reasonable accommodation in allowing that individual to perform those essential functions. Are protected under the Americans with Disabilities Act. Obviously, those who actually have a disability, one who's had such a record of a disability in the past, and of course one who is regarded as being disabled. And this is usually one who obviously does not have a disability, has never had a disability, but you think that they have a disability. And I typically see this in the situation of, for example, if someone is, due to their sexual preferences, you may feel that they are at a high risk for HIV status, and they may not have HIV and never had it, but you have regarded them as being a high risk, or that they must have it due to their lifestyle, due to their sexual preferences. On the other hand, I've also seen in mental conditions where someone doesn't really meet societal norms, you think they're quote-unquote crazy, and you may be finding yourself landed with a claim that you have regarded them as having a mental disability. With regard to these individuals, you must provide reasonable accommodation unless it does impose an undue hardship upon you, and it does require that communication and that interactive process between the employer and the employee to determine what reasonable accommodation may be available to allow that individual to perform the essential functions of their job. When we talk about the Americans with Disabilities Act, we look at the major life activities. What you see in the PowerPoint is not an exhaustive list, but it is the list that courts are typically using. But courts are allowed to add to this list if they deem necessary. And of course, even the EEOC could add to this list without any type of forewarning. But what we do know is the examples that have been given as major life activities does include caring for yourself, performing manual tasks, seeing, hearing, walking, breathing, learning, speaking, or working. It also includes eating, sleeping, bending, reading, lifting, concentrating, thinking, communicating, and standing. And the big thing that Congress added in the Amendments Act is that it also includes major bodily functions. When we talk about the major bodily functions that Congress did add, and I'm going to end up with this last slide and pick up again next time, so but this will be a good time to take to end and then start up again. But when we talk about major bodily functions, we are talking about things with regard to the immune system. Examples that have been given are lupus or HIV or AIDS, normal cell growth like cancer, digestive like Crohn's disease, bowel conditions like ulcerative colitis, bladder conditions like kidney disease, neurological like epilepsy or MS, brain function like schizophrenia, respiratory like asthma, circulatory like hypertension, and endocrine like diabetes, and of course the reproductive. Just to give you a little bit of history on the reproductive part of that actually came from a public accommodations case from the U.S. Supreme Court, in which it dealt with a dentist who had refused to treat a patient because she was asymptomatic HIV positive. And the employee sued, saying that the dentist had violated the public accommodations part of the ADA. And one of the big things was they were trying to figure out, since she was asymptomatic HIV positive, whether she indeed met the definition of disability and whether that did in affect her any major life function. And she indicated that due to her asymptomatic status or due to her HIV status that she had made a decision not to reproduce, and that was the major life function that her HIV status did affect. And the Supreme Court agreed that reproduction was a major life function, and she did meet that definition of disability, and therefore she was covered, and indeed the dentist had discriminated against her in refusing treatment to her due to her asymptomatic HIV status. So let's break up here, and we will start up again talking more about the ADA and the FMLA and some of the general overview of these two important laws.